Bruce Rivers, he's the criminal lawyer.
But who is he?
Bruce Rivers, he's the criminal lawyer.
And who is he?
Bruce Rivers, he's the criminal lawyer.
And what he do?
And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts, CLR Bruce Rivers. I am a board-certified criminal defense lawyer where I react to certain news of the day, certain songs that you guys like and I like. And so today I'm reacting to the updates on Pooh Shiesty's case. Now, Pooh Shiesty is also known as Lontrell D. Williams, and he is indicted in the Southern District of Florida on 4 different counts. Basically, it's a robbery situation where he and a couple other guys are charged with, they went to a hotel, supposed to buy some shoes and some weed, and they wound up shooting him up the place and shot one guy in the ass. So when you have a federal case, you set out these different deadlines. You set out, your motion deadline, your pre-trials, and your trial date. And he was supposed to go to trial on Monday. Well, in advance of trial, if you're going to take a deal, you got to tell the court that you're taking a deal, and that's what happened in this case. Mr. Shiesty, his lawyers have told the court that they plan to enter a plea. They haven't set a plea date yet, but what'll happen is they'll strike a plea agreement with the prosecutor in this case, and they'll they ask for a change of plea hearing, which they've done. Then they'll file the plea agreement so you can see what the actual deal is. So we don't know what he's going to plead to quite yet, but what's he looking at? Well, he's charged with, among other things, 924C. 924C is using a firearm in violation, in furtherance of a criminal offense. And that's a separate crime than the underlying 1951, the robbery, basically. It's a Hobbs Act violation. So when you have that, and if somebody was injured, that adds a mandatory minimum consecutive sentence onto what otherwise would be, a particular sentence. This adds, another like 10 years onto his sentence because somebody was injured. It can cover, it can go up to life if somebody was killed, but he's not going to get life. But and I don't know exactly what the deal is. Nobody does except for the parties. They know what the deal is. But there was an interesting twist to this story because the alleged victim, he was a guy by the name of Brandon Cooper. He's been charged with bank fraud, and so he doesn't really have super clean hands either. And these other guys were armed as well, is my understanding. So you had 2 sets of guys. One set of guys going to buy some high-end shoes and some weed, and then. But if you remember how this case got solved, Mr. Williams and his crew they were in a vehicle, and they had a Louis Vuitton bag that fell out of the car, and over 40 grand in fucking cash fell out of the car. Okay. Now, remember what I said? What does that say right there? What does that say? Stop self-snitching, right? Well, Mr. Williams earlier that day, flashing his money on the screen on Instagram, and guess what happened? They were able to freeze, or I don't know if it must have been a still shot or whatever it was, but they were able to get a serial number off of one of those bills, and it matched one of the bills coming out of the car that fell out of the car. So, when you think you're all fly and all that, and then you put all this crap on Instagram, that's a permanent record. Anything you put online is a permanent record. So so don't self-snitch, Mr. Williams. Nobody should do things that are going to get him in trouble later. Don't put yourself on social media with illegal activity. I mean, you just shouldn't do it. So Mr. Shiesty's trial Pooh Shiesty's trial was supposed to start Monday. When you start a trial, it's the government's burden to prove your guilt beyond a reasonable doubt. They do that by presenting witnesses and evidence in open court, right? And so the first thing you do is you select a jury. And in federal court, the judge does most of the talking, but you're able to ask the jurors questions to see if they can be fair. And you can kick a number of jurors off for any reason or no reason. There's no limit to how many strikes you get for cause. And strikes means you kick them off the jury. It's really jury deselection, not jury selection. And so if they can't be fair, they can't sit on the jury no matter how many of those for cause strikes you use. There's another thing called preemptories where you can just say, I don't want them just because, she's a suburban housewife and I don't think that's the kind of jury that's going to be favorable to me. The only thing you can't do is you can't strike somebody for a race reason, like I don't want black people on a jury or I don't want Jewish people on a jury. You can't do that. So he has indicated to the court that they are not going to have a trial. And so in a trial, the prosecution goes first. They do their opening. Defense does their opening. They call their witnesses. You cross-examine the witnesses. If the defense has any witnesses, you bring those forward. And then each side does their closing argument, and the government gets a chance at rebuttals. That's the structure of a trial. That's not going to happen in this case. In this case, Mr. Shiesty is going to plead. So the first thing they do is they'll file a plea agreement with the prosecutor or with the court, and so they look at the plea agreement, and so you get to court, and the judge will go through your rights, all your rights with you. First, they got to make sure that you're competent. Have you had any alcohol to drink? Have you had any medication? Are you thinking clearly? Is there any reason anybody putting any pressure on you, threats or promises of any kind? Usually they say no. So now you establish the fact that the person's competent and not under any undue pressure to plead guilty. Then you go through the waiver of your rights. So the judge will ask him, you understand you have the right to a trial. At a trial, you're presumed innocent, and go through all the different trial rights that you have. You have the right to remain silent at a trial. Nobody could comment on your silence, blah, 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 blah. So once you do that, then the prosecutor will go through the factual basis section. So you can't enter a plea of guilty if you're not guilty, so you have to admit that you did what they say you did, or whatever the agreement is, whatever you're pleading guilty to, you have to admit that you broke that law. So Mr. Shiesty will be getting up in court, and he'll be saying, I'd like to direct your attention to, let's see, what was the date of this? Yeah, I'd like to direct your attention to October 6, 2020. Do you remember that date? Yes. Were you in Miami-Dade County that day? Yes. And in fact, you went to a hotel that day with two other people, Bobby Brown and Jaden DeRosa, right? Yes. And what did you do that day? Well, we went there with some guns. And you know that the two of you conspired. You conspired with more than one person to commit a crime, right? And then they'll go through all the facts. And then once they're done with that, the judge will usually accept the plea, and then they'll set it on for a sentencing hearing somewhere down the road. So within a week or two, he'll have to meet with probation, and probation will create what they call a pre-sentence report. It's a big, long document that's for the judge. And in federal court, what they do is they give you a preliminary pre-sentence report. You go through it with your client, and you decide, is there anything in here we need to object to? Did they get the guideline calculation right? Are these facts right? Go through your family history, go through your drug and alcohol use, go through your educational history, and your criminal history. Is all this stuff in here accurate? And sometimes it's not accurate, so you file objections, and you either work it out with probation, or you can just note your objections, and then you argue it. Then you get the final pre-sentence report. When you get the final one, you draft what's called a position paper. Basically, it's the sentence you think that the judge should give and the reasons for that. So you do your own guideline calculation and say, the judge, and you're going to be bound to argue within the parameters of the plea agreement. A lot of times there is no limit to what the defense can argue for. And then you also have an appeal waiver. So as long as a sentence is within a certain range, you waive your right to appeal. My sense is one of two things happened here. The fact that one of the witnesses in the case is now charged federally probably makes that person a little less credible. So maybe the government felt like they could give him a better deal now that they know what piece of shit their complaining witness is, or how damaged their complaining witness is. Or he just sees the writing on the wall and, thinks, there's just too much risk to go to trial. Let's cut our losses. And the latter is probably more likely true than not true. And in this case, he's looking at a boatload of time. You've got a Hobbs Act violation and a 924C count. So that would mean, the guidelines are going to be, in excess of 10 years. And there's a lot of things that go into the calculation of the guidelines. So you can see there's a chart. So you can see by this chart here, the top line is your criminal history category. So if you go across wherever your numbers lie, that's your criminal history category. And I don't know what his criminal history is, but he's detained in this case, and he's been in jail, I think, since July, if I'm not mistaken. And then the severity level of the offense goes down the other side. Now, here's one of the things in the federal system. There are various factors that, in this case, and in every case, that will enhance a sentence. So you have a certain base offense level, and then if there's a gun used, you can add, so many more points. If somebody was injured, use so many more, and so on. If there's sophisticated means, if there's, whatever. There's a variety of different types of enhancements that you don't have in most state courts. And so then you find where your guidelines are, and then and you look at it and argue what you think a fair sentence would be. And so he'll enter a plea probably in the next week or two, I would bet. It won't be long. And so once he enters his plea, then they'll do the PSR, pre-sentence report, and then that'll be about 8 to 12 weeks, I suppose, before he gets back for sentencing. So he probably won't be sentenced until after the first of the year. But his trial's off. He's going to plead, and it's really a shame because this is a big sentence. This will be a big sentence for him, I don't know what his defense would have been otherwise. Probably would have been self-defense. That look, we they had guns and they brought their guns out, and that's what caused us to do this. And from the likes of it, it doesn't look like they thought that was going to be that successful, so they struck a deal. So, with that said, I wish Mr. Williams the best. He's an excellent artist. We've done a reaction to him before, and we'll do one again. So if you are watching this, you should like, subscribe, follow us on Instagram, follow us on Twitter, and why don't you sign up for Patreon? You get 3 months, you get a free hat, or just go to Shopify and go get a hat. They're going like crazy. So appreciate all the fans, appreciate your support, and we'll see you next time here on Criminal Lawyer Reacts.